Welcome everyone to our Kinship Caregivers Connect presentation. A big thank you to our presenter, Senior Attorney Joseph Warden from ABLE. He will be presenting on kinship legal guardianship as an option and answering some questions. He is so knowledgeable on kinship related issues, so thank you so much, Attorney Warden, for being with us, and I hope this presentation is helpful.
Hello, everybody. I am very happy to be here this morning. And, I like doing trainings that are, it's an old cliche, but are near and dear to my heart. And this with kinship caregivers, and the work we do with kinship caregivers, it is near and dear to my heart. It is so important to have done, to have some type of legal authority for any children that may be with you. And I always like to use a little prop in some of my trainings. And it was kind of interesting because this afternoon after lunch, I'm actually going to file a guardianship out in Greene County for one of my kinship caregivers. And I thought, not to scare you all, but this is the file. You can take a look at that. And it's not that it's especially difficult to do a guardianship. It's just there's a lot of paperwork. Okay. And we're going to talk about all that and hopefully give you all the confidence if either you or another kinship caregiver needs to file a guardianship. You can say, hey, I was through this training and it's not that bad. We're going to go to the county where you live. We're going to look up the probate court. They should have form sections, and we're just going to follow a checklist. A little more complicated than that, but anyways, I just want to let you know that I will be filing this today.
That is quite the prop.
Yeah, so it's just kind of coincidental. Anyway, my name is Joe Warden. I'm a senior attorney at Advocates for Basic Legal Equality. I am based out of our Dayton office, and I have been the lead attorney on our medical legal partnership for children for the last, oh, goodness sake, 10 plus years. And we'll talk a little bit about a medical legal partnership for those of you who don't know what that is in just a moment. I've got to get through some of the other things here. This slide generally tells you we are a nonprofit regional law firm. We provide high quality legal assistance in civil matters to low income individuals in groups in Western Ohio. The goal, obviously, to achieve self-reliance, equal justice, and economic opportunity. I keep those ideas at the forefront of every case I'm working on. And those are very important goals to have. So I want to tell you a little bit first about a medical legal partnership, because depending on where you're all at, various hospitals around the state, such as out in Columbus and Cincinnati, their children, Nationwide Children's, Cincinnati Children's, they all have medical legal partnerships, which is great. If you all have kiddos that go to these places, you can access the medical legal partnership. And what that is it's a healthcare delivery model to improve population and health. And what it is that it's based on really that evidence that an unmet legal need can undermine health outcomes. For example, we have a family living in substandard housing conditions, mold, infestation, lack of water, lack of heat. You all can imagine how much that is affecting a family's health. Okay. So by bringing legal services right into these healthcare settings, they can get access to an attorney, mainly through their social work department. The social workers screenings at all these different hospitals will talk to you about issues such as housing, education, safety, legal matters such as guardianship or custody. And this number, 450 MLPs in 49 states, it's probably gone up since then. But I can remember back when it was first getting started, they said, Joe, you're going to work on the MLP. And I'm like, what the heck is that? You know? So what we do is we talk about social determinants of health. everything we are, where we live, where we work, where we go to school, the quality of food we eat, having money to buy food and pay your utilities. These are all what we consider social determinants of health: education, financial resources, family stability, healthcare, food. These are all social determinants that impact your health and the children in your home. Okay. And we'll move on just a little bit here. Okay. So the reason this is so important to bring legal services into healthcare settings, because quite frankly, um, people trust their doctors, they trust their nurses, they trust the people that provide healthcare for them. And the healthcare world is in a unique position to talk to their patients and their families. How's everything going? Everything good at home? How's your child doing in school? So these are things that when the doctor hears this, he can say, hey, we have a medical legal partnership. I think we can help you with that issue. Okay. Any questions on a medical legal partnership? I know that was just kind of a quick kind of synopsis. Um, for me, I work out of Dayton Children's Hospital. I work out of Rocking Horse Community Health Center in Springfield. I work out of the Five Rivers Health Centers here in Dayton. We take referrals from the community health centers here in Dayton. So we do have quite a few partners. We also partner with Care House, which is attached to Dayton Children's, for those cases we receive where a child has been abused. I won't get into all the gritty details of that, but it's suffice to say we get referrals to file protection orders. Maybe it'll lead into a divorce type of situation, and we'll work on those as well. Okay, we can skip that one because we kind of talked about social determinants of health can be broken down into 7 key areas. And I'm not going to repeat those again, but they're right there on your screen because we're here for guardianships. So I just want to give you a brief overview of the things we look at. And so you go back to those, and let's say something like education. All right. And how does that impact a child's health? Well, that child may need an IEP, may need an evaluation. Maybe that child is having attendance related issues or disciplinary related issues for which there's a medical or a psychological reason that perhaps is not being addressed. So that's why, we have our education lawyers who can look at those things. We look at financial stability, Social Security matters, SSI cases for children. All right, we do a number of those. Healthcare type issues. Becky just worked on a contested case where this child needed a special bed to keep this child safe. This child with medical and mental health disabilities is like a safety bed, as quite expensive. And that was being denied. We took that case, and Becky, if you're here, I don't know if you are, she won that case. That was an important case. So medical equipment related issues. We're working on one right now where this child needs a wheelchair. Actually, this child needs 2 wheelchairs. And we're working on that because that's been denied and held up and got into all kinds of bureaucratic red tape. So sometimes the lawyers getting involved can sort that out. Okay. I get a lot of referrals on housing conditions issues, mold issues, child suffering from asthma, lead paint. So these are all how the social determinants of health, you can kind of see how they tie into what attorneys can do. Okay. And we already talked about the legal areas of impact, such as eviction, custody, denial of benefits, restraining orders, education, guardianships. One of the things that's not on there, although it does say custody, is, for a grandparent, a kinship caregiver, for the most part, y'all are going to be in juvenile court if you get involved in some kind of custody battle. And we do quite a few of those. I've got a pretty difficult one going right now. Let's see. Okay. And so I wanted to give you a brief overview of the MLP, and that's probably got a lot of questions, but I do want to move into guardianships. Okay. A guardianship of a minor. a child or a person under the age of 18. It's a legal relationship where you would be granted legal authority and a duty of care for the minor, okay, and the minor's property. Well, that kind of depends. We'll break that down. And I give you the Ohio Revised Codes code section. Any person less than 18 years of age who has neither a father nor a mother, or whose parents are unsuitable to have custody of such a minor, or whose interests might be promoted by a guardianship. Okay. And so there are some terms you need to learn. The first one is ward. The ward is the minor child. All right. That's the minor is receiving the guardianship is called the ward. And the person who's applying for it, the applicant, is called the guardian. Okay. Different kinds of guardianships. Now, the only ones we work on here at ABLE are guardianship of the minor's person. That puts you in a position to make medical decisions, healthcare decisions, life decisions. Okay, those are the only ones we do. We would not necessarily see guardianship of the minor's estate where the minor has some money and you have to have authority to spend that money. Most of our cases, there's just Social Security involved, and most of y'all would be already appointed as the payees. I have worked on a couple of cases where I did have to file a guardianship for the minor's estate, where I had a mother or father pass and left some insurance money to a minor, over 25,000, and we have opened those type of cases to get that money put into a guardianship. But the ones we mainly work on are guardianship of the person, okay? And they make me put this in red at the bottom. The probate court is always the superior guardian, and of course, you all would obey any orders of the court. Did that drum up any questions thus far? What is a guardianship? It is where you are in a position of being legally responsible of the care of someone who is unable to manage their own affairs. Okay. And in this case, we're talking about minors under 18 years of age. Okay. They're not considered an adult. They can't make decisions for themselves without the consent of parents, or if the parent's not there, the guardian. A guardianship is needed for an 18-year-old child. And we do a lot of these 18 and above where he or she is unable due to disability to make decisions or care for themselves. And we get quite a few referrals from our providers. So a mom, dad, or a grandparent has an 18-year-old who is otherwise disabled, cannot care. So they need to file for an adult guardianship on somebody 18 years old. Okay. Incompetency, Ohio law defines it as any person who is so mentally impaired as a result of mental or physical illness or disability as a result of intellectual disability or chronic substance abuse. That person is incapable of taking care of themselves or their property. All right. Now, how do we begin this? As I said, here in Montgomery County, our probate court is just outstanding how they have it set up. And I would say for any of you who are considering filing for a guardianship, no matter what county you're living in, go to your probate court website. Most of the courts now have their own forms and their checklists, or they will refer you to the Ohio Supreme Court forms, which are acceptable throughout the state, and they have those forms. I'm talking specifically Montgomery County, but it's pretty much the same every county you're in, although some courts, they have their own specific forms. That's why it's very important to check out the probate court website where you live, read their local rules, read the instructions about filing guardianship. That could include filing fees. It could include information on how do you serve a parent, maybe if you don't know where that parent is anymore. We see a lot of those. Maybe we know where mom is, but we don't know where dad is. So it'll give you instructions because the parents have to be served. Okay. And there are different ways for doing that. You can file your application. As I said, there are a lot of forms to fill out. But once you get them all done and signed and notarized, you'll take them in to get filed. Or here in Montgomery County, we e-file. The court will send an investigator. It kind of loud, sounds like an ominous title for somebody. They work for the court, but they will come out to the home with the guardianship papers to serve. They'll talk to you a little bit, and then they'll present a report back to the court that, yeah, it looks like we need a guardianship here. Okay. Um, so I always tell my clients that, not that we want, we all live in our houses, but and it's not like children's services is coming out, but I always remind my clients, the investigator is coming out, so pick up just a little bit. Okay. Um, I'm saying you don't have to be spotless or anything, and it's not like they're going to be going through your cupboards, but I think it always looks good for an investigator to come out and the house is neat and organized and your minor is neat and clean and appropriately dressed and that kind of stuff. Okay. So, okay. Some of this is really related to anyone over 18, but really it could be for a minor. The ward has the right to be represented by an attorney. If I have an 18-year-old, I haven't had this come up yet because most of the guardianships I file for those young people over 18, they have pretty significant disabilities. But you might get a case where a ward says, no, I don't want you to be my guardian, especially if they're over the age of 14 and they have the right. And if they tell you that, you have to let the judge know. They might appoint a lawyer for the ward. I've not had that happen yet, though. Okay. The court mails your guardianship application to people entitled to service, and that would be the moms and dads. It's called a form. It's a next of kin form. The one I'm filing today, we know mom and we know her address. Dad, we don't know. That he has not seen this child since I think the child was 3 or 4 days old. And so the question becomes, well, how do we get service on someone like that? Well, you might have to do service by publication, and that costs some money to run an ad in the local paper. That you've seen the legal notices. In this case, I filed a motion with the court. I'm trying to get the court to actually waive that, to dispense with that service, because quite frankly, dad's not been in this child's life for a very, very long time. So you get your paperwork filed, everyone's served, and then you go to your hearing. These hearings are they're not hotly contested necessarily. The court will review the guardianship. It's a pretty friendly affair. You'll be in court. A judge will look things over, ask you a few questions. The judge will look over the all-important statement of expert evaluation. I think there's a slide on that. Those are for my kiddos over 18, where a doctor is saying, yes, this adult does need a guardian. For the minor guardianships, it's simply a matter of putting on the type of evidence and testimony. The judge will probably walk you through this, that you're the caregiver, the child lives with you, how long the child's been with you, those sorts of things. As I pointed out, our probate court has a great form section. And if you're filing here in Montgomery County, I would advise any of you to look at that. And also here in Montgomery County, they actually has a person down there. You can go and see the person. They have office hours. They'll actually assist you in filling out all the forms you need. It really, in these guardianships, and if you're doing it pro se without a lawyer, that's a great place. And I imagine Franklin County would probably have something like that as well. Some of the smaller counties, they don't necessarily have a big form section. They might direct you to the Ohio Supreme Court website. But here in Montgomery County, on this next slide, I'm giving you a list of all the forms necessary to file your initial guardianship, a minor guardianship application. And we'll just go through a few of those. You've got actually your application, your next of kin. There's a form that's going to set a hearing. You got to take an oath. Waiver of notice and consent. Let's talk about that for a moment. Let's say you're a grandparent and your grandchild's or grandchildren are living with you and you want to file for a guardianship. You can talk to the parents. Maybe they'll sign that waiver of notice and consent to it. Maybe they will, maybe they won't. Quite frankly, I get quite a few parents who said, yeah, absolutely. Then I get other ones who just won't sign it. If they sign the waiver and notice of consent, that's great. They don't have to, they'll be served, but that is an option. You can see that if you cannot afford to file the guardianship, which I believe is 300, a little over 300, I think here now, you can file this affidavit of indigency. One of the things you will have to do is to get your background check done. That's literally every guardianship case anywhere in the state. That does cost, I think at last I checked, I think it was $45. And that should be, you'll fill that out and that'll be sent to the court, your background check. In cases where we can't find a parent in Montgomery County, they actually have this form called affidavit search for address, where on that form, you're going to say, I've checked websites, I've checked Facebook, I've put the name in Google, I've checked court, I can't find this person. Okay. And again, just to encourage all of you to check your local probate court website for the forms and rules, because every court does it just a little bit differently. Okay. I put a form on here and I apologize if it's not too big. I just wanted you all to see a couple of forms. This one is the application. You can see right at the top of every probate form, a guardianship of, you're going to put your ward's name there. And then you can see in the first paragraph, applicant, a resident of Montgomery County. You want to be the guardian. It's again, these are, they look complicated, but if you actually start looking at it and thinking, oh, that's not too bad. A guardianship is necessary because in a lot of these cases, you're going to say that the parents are unable to care for the child. The child has been living with me for however long. I need legal authority to make decisions such as education and healthcare. Those are two really big ones. Type of guardianships, you have your selection here. For us, we always check person. If it's for a minor, the definite time, the definite date will be until the 18th birthday. Okay. Over on the other page, they want you to list off any personal property, real estate, but most of those will be zeros. Maybe other annual income, you'll have Social Security in there. So that's a pretty basic form, and that starts the whole process. Next of kin, again, this is an important form. This is where we usually put mom and dad down here. Okay. You can see off to the left, there's a box. If they'll waive service, you can check that box. Again, they don't have to. That's that affidavit search for address. If you can't find a parent, and this comes up quite a bit, I think the case I'm working on now, I think that fella is homeless, kind of living from place to place, no set address. And sadly, we do see that quite a bit. This is the affidavit of you as the applicant. Now, let's say in the past, you've had some run-ins with the law. Maybe no one's perfect. You've had a few things happen in your lifetime years ago or even recent. You must list these things out. You must be honest and truthful with the court because they will see it on the background check. And there's nothing worse than not being honest on this. The background check comes in and you tend to lose a little credibility in front of the judge. So I've had parents who have had, let's say they had a shoplifting charge years ago. Yeah, put that down there. That's going to show up. So that's an important form. And as always, on all these forms, be very honest, be very truthful on all these forms. This talks about the type of charge, the course, were you convicted, those kinds of things. And so that is actually an important form, you know, but for most cases, my clients will have this nothing here, but I do get those occasional cases where something pops up. Waiver of notice and consent, that's the form we talked about that the parents can sign. Okay. And that's good for really any probate court in the state. Every probate court has some type of waiver and of notice and consent form. Now, once you're appointed guardian, you do have some duties. You just don't get the court appointment of guardian and walk away. Okay. You do have to file some different things, such as the guardian's report. It's about a 3 or 4 page kind of check off the box kind of thing. The guardian's report, the plan. What is your plan? How's your ward doing in school? Child change school, you get the child in other programs. That's your guardianship plan. For my kiddos over 18, the statement of expert evaluation has to be filed every other year. But if the doctor on the second time, the second statement says the condition is not going to change, no further reports will be necessary. So you got your report, your plan. And what I do is, even when I complete a case, for the most part, I stay on the record as the attorney because we all have very busy lives. And sometimes one of my clients might forget the guardian's report was due or the plan was due. So I will get that notice. Maybe my client is moved and they didn't let the court know with the change of address. So it keeps me in the loop and allows me to try and get in touch with them and say, hey, the court needs this report. And if you don't provide it, they're going to bring you into court and they can terminate this. So for me, I try and stay on those cases. And if I ever get something like that, I immediately try and contact my client, a way to catch up and just remind them that this is due. Okay. Oh, and also in this state, when you're a guardian, you do have to complete continuing legal education. I think it's 6 hours the first year. You can do it in 2 increments and file that certificate with the court called guardianship training. Your local court will talk to you more about that. Okay. And jumping back to what we do and how I get a referral, and then we'll talk about all your questions. This is our standard referral form that our partners send to us. And it's pretty basic. We want this to be a very smooth process. They put down who's making the referral. It could be, Jane Doe, social worker, Dayton Children's, their phone number, the name of the person who needs assistance, the contact info, the patient's name, the relationship to the patient child. And then we give you a series of boxes you can check for what type of case it is. And there's also, let's see if no, they didn't include. The second page has some lines that whoever refers the case to us can also write out a little narrative. And I always appreciate that. So it's a pretty basic form that gets emailed to me or faxed. I review it. I send it up to intake. The intake process begins, which basically legal aid line is going to call you. They're going to go through the household income to make sure you're financially eligible. And then we have to run a conflict check on all the names involved in the case. So if we have Jane Doe wanting a referral on a guardianship, but we had previously represented a mom or a dad in a custody dispute and that same child, we would be conflicted out. So conflict check is very important. Let's see what else. Oh, this is just kudos for our program. We look to improve patient health, outcomes, well-being, and mental health. Obviously, to reduce stress in these guardianships, it is stressful to get them filed, but once you get it done, you're going to feel good. You got some legal authority now. You can give the school a copy of your appointment papers. You can provide that to doctors, dentists, mental health providers. Let's see, address issues, family stability, kinship caregiving. It's just a huge part of our practice. And Angela and I were just talking about this yesterday, how important this has become with kinship caregivers, because I've been at this for a long time. And I'd say over the last 10 years, I haven't really kept track of the numbers, but ever increasing, we are seeing kinship caregivers play that more prominent role in a child's life due to the parents being unable to care for that child. And I don't see those numbers going down at all in the future. If anything, it's just going to get I don't want to say it's going to get worse. That's not a proper term, but I just think we're going to see more and more of this, where parents impacted by, for example, substance abuse, impacted by domestic violence issues in a home where it's not safe for that child to be there. A lot of things going on that make the kinship caregivers so important, um, to a child. These are all the counties we work in. Okay, so we cover a lot of counties, 32 counties. And there's my contact information. And I want all you to write this down or whatever. I do not mind phone calls. I do not mind emails. I don't mind talking to any of you. I could probably only go so far if you're not actually a client. But if you get with Angela, uh, she can get a message to me, and we can see what we can do to help and assist, or whether it's a case that we actually might be able to take on. But I don't mind emails. All of my social workers and my community health workers, they all know they can get me, and I will respond to them. Okay. That is such a brief overview, but I just want to tell you all that, if you need a guardianship, it's nothing to be afraid of. You can do it. You'll find that the courts are very receptive, to pro se persons coming in. Most of these guardianships are not contested, so you can put your mind at ease. But let's go for some questions.
Yeah. Well, first off, thank you so much for all of this information and all the work that you do. I can definitely say you're a very responsive person, and really taking that holistic approach and seeing the caregiver's perspective is so powerful. So we're just very grateful to you and to Able as well. And yeah, if you don't mind, I'll just like scroll through our list of questions. Our first question was, does the court deny guardianship on the basis of age?
I really don't know. I've seen guardianships for minors. I've seen guardianships for young people. I've seen a lot of families who have to file guardianships for, let's say, a parent who's now a senior. So I would say no. And I'm not, whoever gave that question, if you want to be, maybe I'm not getting the question. Um, but no, I mean, guardianships are done for minors. They're done for adults over 18, obviously seniors. Um, I've been involved in all those kinds of cases. So no, it wouldn't be denied on age unless you're talking about the applicant. The applicant has to be 18 years old. I've had young people. I had a case a while back where a mother tragically had passed and dad was nowhere to be found. And I think she was 19 at the time. She stepped up and began taking care of her siblings. And I think we filed a guardianship on that. But again, she was over 18.
Yeah. I'm just scrolling through the chat, and then we had a comment, Lorain County has a help desk and a law library available. So I don't know if there's resources like this in other counties, but that is good to know. Maybe if you don't have
Mhm.
a lawyer available, to use some other
Yeah.
resources you use.
And, and I would just add that if you're going to do this pro se and go do a guardianship application, don't get discouraged if you go through their checklist and you bring in the forms and they look through and say, or they call you and say, hey, you're missing this or you're missing that. I mean, the reality is, a lot of times, even the lawyers, I might go in today with all my forms and say, hey, Joe, you need this. And so you might be told to come back and get this form and just do it. It might take you 2 or 3 times, but you can do it.
Absolutely. So we're going to keep them coming.
All right.
This is the golden question. What is the difference between guardianship and legal custody?
That is the question. I knew what I was actually going to bring it up, and I said, no, somebody's going to bring it up. So,
Yes.
here's the way to think of it. Obviously, we think of legal custody as, let's say, the gold standard. All right. That, you have legal custody. And if somebody wants to take that custody away from you, they're going to have to go in court, and they're going to have to really meet a high burden there. Guardianship is very similar. You can do all the same things. I think in a guardianship, the parent could come in and say, well, I don't want you to be the guardian. They could file to have you removed. Um, Best interest is what the probate court is going to look at. Okay. If I'd had my rathers, I would rather say legal custody is the way to go. Sometimes a guardianship is easier. Um, it's easier for a parent to handle. Oh, you just have guardianship, you don't have custody. Well, you've got essentially all the same rights. And I think, rather than if it can be worked out by doing a guardianship, we do a guardianship. Um, it's just no hard and fast rule on which is better. I look at custody as stronger. I think legal custody is harder for a person to challenge. Um, but I'm okay with either. And we've had cases where we've had to make that decision. Um, I had a case up in a county up north where um, it's just a tragic case. But anyways, I had a grandmother who was trying to get either legal custody or guardianship of her minor grandchild, and they didn't want to file for legal custody and have that being on record and trying to take custody from their daughter. So they felt much more comfortable with doing a guardianship, and that was fine. That was absolutely fine. That probably did not answer your question.
No, she said, thank you. Final trial for custody is beginning in January. She appreciates the
Yeah,
clarification.
yeah.
It's very helpful. Um, and then this kind of adds on to the question. Someone else asked the difference between legal custody and adoption.
Yeah, well, the adoption, obviously, the adoption, if it's granted, basically it would sever all ties with the parents. Then they have no more visitation rights. They have really no rights to that child. Any rights of visitation or future contact would be up to you as the person who did the adoption. And we've done a number of adoption cases, and they are difficult. But certainly, I have I have one case I'm thinking of now where she's had this child for a very long time and no word from mom or dad and no child support or anything. She is filing for adoption and she'll probably get it, which is great. Um, yeah.
Yeah, you're getting lots of love in the chat. And so thank you again so much for your
All right.
time. So sorry I missed your question, but glad you were able to ask that. Yeah, I'll see you all on Thursday. We have another great presentation. And if not, see you all next week.